thank you also to the organizers for asking me to come along. I hope you'll forgive me if some of the points that I'm making in my pre-prepared script are actually points that have already been brought up in the discussion. I suppose that's inevitable. The awkwardness of talking to a screen and a camera with an unstable internet connection means that I'm rather more worried about improvising than I would be if I were addressing people face to face. But anyway, the topic that I'm going to address is praxis, and that's in the narrow sense of the exacting of debts. This is rather pedestrian compared to the papers that you have just heard, but I'll try to argue that it's actually quite an important aspect of civic administration, which may tell us something or raise some questions about influences and dissemination of ideology as well as legal practice. The legal term praxis, along with its cognate verb pratein, is used both about debts owed to individuals and debts owed to collective entities, and that includes cities, sanctuaries, civic subdivisions, and private associations. In this paper, I'll focus on the latter category, i.e. the collective entities, and in particular on debts that were incurred as a result of penal decisions made by courts, councils, and officials who had authority to impose summary fines. There are several reasons why praxis is of relevance to the conference theme. The most important is that exaction of monetary penalties owed to collective entities often depend on processes that are potentially of enormous political and ideological significance. In his politics, and I don't know if you've got the handout, again, I apologize because my device does not allow me to share my screen. But on the handout on passage 1, Aristotle defines the office tasked with exacting judgment debts and proceeding against persons who've been registered as public debtors as both the most indispensable and perhaps also the most difficult. He explains that it's the most difficult because the task often attracts hatred, and it's indispensable because it's pointless. He says that lawsuits concerning matters of justice should take place without the procedures being brought to their conclusion. Consequently, if it's impossible for people to interact with one another when lawsuits do not take place, so it is when praxes do not happen. Crucially, the effectiveness and impartiality with which such penal decisions are enforced in practice can profoundly affect the level of public trust in the integrity of the administration of justice as a whole. In a modern context, it's not just a perception that blue-collar criminals are unjustly favored by an allegedly soft or lefty parole system that can fan the flames of penal or punitive populism. So can the perception that the wealthy and well-connected frequently succeed in evading monetary penalties by gaming the system, for example, by concealing their assets in ways that are not normally available to ordinary citizens. Just as threatening to internal political stability and public trust in laws and civic institutions is the fact that the process of enforcement might be abused by those who've been granted authority to carry it out. Effective debt collection, ancient and modern, often involves the straining upon the debtor's assets. This often means that the creditors or their agents would be crossing the boundaries between public and private, entering into the private homes of their fellow citizens with authorization to seize and remove personal possessions belonging to the debtor, and sometimes even to arrest the debtor him or herself. Here in the UK, concerns relating to the process have intensified in recent years, particularly in connection with the outsourcing by government of civil enforcement, including the power to arrest, in England and Wales to 3 private corporations, with the value of the contracts depending on the number of warrants executed and the value of the goods recovered. Even before this decision to outsource, this charity Citizens Advice reported no fewer than 103,000 bailiff-related complaints between March 2018 and March 2019, According to the charity, this was driven by a rise in bailiffs not following the rules of right of entry. It's not difficult to see why such issues would be regarded as extremely problematic as an aspect of law enforcement, also in an ancient Greek context. In the passage mentioned earlier, Aristotle claims that unless incentivized by the prospect of sizable personal profits, citizens will be reluctant to stand for offices directly related to the exaction of debts because of the hatred associated with the task, or if they do agree to serve, they will refuse to carry out praxis according to the laws. Unless the community operates with robust processes of public accountability, the process of praxis offered alarming opportunities for personal enrichment by those authorized to enter onto private property to exact debts on behalf of the collective. A further risk factor, especially in a small community, was that those carrying out praxis might be tempted also to let personal sentiments of friendship and enmity determine the level of ruthlessness that was applied in the process. The divisive effect of debt collection should thus not be underestimated. The risks surrounding the process were likely to be highest in communities that combined property qualifications for office holding with the vesting of significant authority in one or more boards of officials with responsibility for praxis. In a community that was already teetering on the brink of stasis, heavy-handed collection of judgment and contract debts might contribute to pushing it over the edge, especially if carried out by officials that were perceived as belonging to the elite. In modern discussions of Greek stasis, including in the Hellenistic period, the connection between internal conflict and high levels of personal indebtedness is often highlighted. However, the process of praxis itself, not least its interpersonal dimensions, deserves more attention as a potential catalyst. Concerns about excessively lenient and excessively heavy-handed exaction of penalties are well attested not just for classical Athens. Inscriptions from numerous other Greek communities, especially from the late 4th century onwards, suggest that these concerns were widely shared. It is not in itself surprising that many communities attempted to strike a difficult balance between providing incentives for agents in the process of penalty enforcement, while at the same time limiting the scope for abuse, especially by officials whose remit included the authority and sometimes even the obligation to exact judgment debts, summary fines, or fines incurred as a result of a breach of contract. What is noteworthy is that many Greek communities across the Aegean, Asia Minor, and several regions of mainland Greece seem to have operated with remarkably similar measures in order to address the problem. Yet how far such similarities can be identified as a part of an Athenian judicial and institutional legacy is a question that I still find tremendously difficult to answer. So is the question of Hellenistic legal and institutional convergence as far as this particular aspect of law enforcement is concerned. I'll return to both questions in due course after a brief excursus on classical Athens and some of the problems presented by our available evidence. Modern discussions of Athenian legal ideology have tended to concentrate mainly on the initiation of legal procedures and on the argumentative strategies deployed by litigants and their supporting speakers in courtroom. The processes by which verdicts were executed and summary fines were exacted have received less attention by comparison in their own right. Sure, they feature regularly in discussions of procedures such as apogoge and endixis, apographe and phasis, all of which were available against individuals who owed debts to the public treasury, to a sanctuary, or to a civic subdivision. But an important shared feature of these specific procedures is that they all appear to have depended on volunteers for the initiation. Although it must be emphasized that a citizen holding a relevant office would not be prevented per se from volunteering, there is a significant difference between this type of initiative and the kind of initiative that an official was legally required to take because of his official remit. The emphasis in modern scholarship on the part played by volunteers as agents in the process of praxis is to some extent a reflection of the nature of our evidence for classical Athens, and that includes both the literary and the epigraphical. In our literary sources, references to direct, active, ex officio involvement in the process of exaction are remarkably thin on the ground, considering how serious the issue is. A few precious passages provide us with some pieces of the jigsaw puzzle. As far as the 4th century is concerned, there's evidence for demarcs playing an active role in connection with the collection of certain types of debts, as you can see in passage 2 on the handout. In Demosthenes 58, passage number 3, a speaker anticipates and refutes an argument from his opponent to the effect that state debtors should not be treated as such unless and until their names have been passed on and recorded by the Athenian Board of Praxis. And the speaker claims that this, of course, is not true. Now, it's very likely that the speaker is misrepresenting or twisting his opponent's argument as a kind of reductio ad absurdum. But even if this is a case, the passage still suggests that the Board of Praxis would regularly be involved in the registration of debtors, and thus that they may have played a significant administrative role. Frustratingly, though, it's impossible to determine the extent of their agency, and above all, to what extent they were authorized to cross the thresholds of private homes occupied by the debtors. A passage from Antiphon 6, passage number 4, provides another important piece of information, namely that the Praxis cooperated with other boards of officials involved in financial administration. This phenomenon is also attested in the festival regulations from Eleusis, number 138. Here it's stipulated that the basileus, who is given authority to issue summary fines in a festival context, is to be accompanied by one member of the Board of Praxis and a secretary. In both instances, cooperation by members of different boards may have been intended as a way of enhancing accountability on the assumption that the officials would have an interest in policing each other. A comparable form of cooperation is attested in Lysias 9, passage number 6. Here, a defendant has landed himself in trouble because he's contested a fine imposed summarily by the Board of Strategoi. In the passage concerned, he relates how the generals themselves had refrained from carrying out praxis, but had instead registered his name and passed it on to the treasurers, the termii, when their own period of office was about to expire. The speaker suggests that the strategoi had had a choice, i.e. that they had the authorization to exact the fine, but that they had preferred not to use it. And if the speaker is correct, or my interpretation of the speaker is correct, we can infer that the authority to carry out praxis was shared between different boards rather than vested in a single office. This is actually very much in line with the Aristotelian recommendations in passage number 7 that are represented as a way of reducing the social costs that active involvement in praxis might entail for the persons tasked to carry it out. And finally, a couple of passages from Demosthenes 22 and 24 explicitly make a connection between the process of praxis that is constrained by the laws and demokratia as a form of constitution and a way of life. In both passages, the speaker contrasts the spirits and principle of democracy with the heavy-handed methods allegedly employed in connection with the exaction of unpaid aisphora, instigated and spearheaded by Androtion, with authority granted by one or more decrees passed by the assembly. The speaker describes in graphic detail how Androtion entered into the homes along with the 11 and accompanied by members of the Board of Apodecti, causing the debtors to hide under their beds or escaping across the roofs to their neighbors' houses. This account is complemented in 24 by a graphic description of how Androtion and his entourage of officials and assistants mercilessly removed doors, ripped people's bedclothes from under them, and destroying the female servants. Now, Diodorus, the speaker's story, is particularly valuable evidence in two respects. First, although he asserts that Androtion's decree proposal was unlawful, paranorma, it was not successfully challenged in a graphe paranormon. Considering that numerous Athenians might have had an interest in having the decree overturned, this permits the inference that there was no Athenian law that explicitly prohibited the application of such methods. Secondly, however, the speaker's tone of indignation, combined with his explicit comparison of Androtion's methods to those employed by the 30 tyrants, with the 30 tyrants coming out in a favorable light, strongly indicates that it was highly unusual for Athenian officials to engage in active debt collection so zealously. It's possible that this reflects an Athenian preference for methods and procedures initiated by ordinary citizens as volunteers, such as apographe, which is much better documented. Yet, the significant gaps in our literary and epigraphical evidence for the administrative procedures associated with the exaction of public debts, including judgment and contract debts, constitute a warning against overly bold arguments from silence. It's also important to bear in mind that much of the written record produced for the purposes of praxis was likely to have been on locomata or other perishable material, with records inscribed on stone being the exception rather than the rule. So this then brings me to the next question about a possible Athenian legacy. Officials constrained by collegiality, board members policing each other, multiple boards being involved in different parts of the process of penalty enforcement, each board having a specific and limited remit. The prospect of oathini, along with regular oversight of officials exercised by the council, as we see in the passage from Antigone 6. All of these things, along also with the invitation to volunteer citizens to play an active part in praxis, this sounds so extremely familiar and comfortable in a classical Athenian context. And if we believe Diodorus, this is actually, those constraints of the city's official were construed by the Athenians themselves as a particularly democratic way. But how Athenian were they really? And were they even particularly democratic? Before we take Diodorus's words at face value and identify these features as part of an Athenian judicial and institutional legacy in a Hellenistic perspective, these two questions have to be addressed. First, it's important to note that the earliest attestations of several of these features are from communities outside Athens, and that some of these attestations predate the period where the Athenians began throwing their weight about in earnest in the Aegean and the Eastern Mediterranean. The earliest attestation of volunteer involvement in the process of praxis is found in a fractory regulation, passage number 9 on your handout, from late 6th century Paros. And a slightly later Parian parallel shows clearly that this is not to be treated as a fluke. The principle of collegiality, combined with control exercised by one board of official over another in connection with the process of praxis, is attested already in 6th century Gorton. As for attempts to impose legal constraints on the seizure of personal property and satisfaction of the debt, it is possible that a 5th century Gortonian law, which is actually attempting to do precisely that, although here the interpretations are open to debate. These examples taken together point to the conclusion that the procedures and principles attested for classical Athens are not necessarily either intrinsically Athenian nor intrinsically democratic. Of course, questioning the Athenian position as proto-heretai does not necessarily rule out that the Athenians as a hegemonic power may have acted as a vector in the dissemination of legal procedures, institutions, and principles. But particularly in the light of recent scholarly emphasis on the importance of networks and of horizontal engagement and exchange between individual communities and regions, it's extremely difficult to gauge the extent and the depth of Athenian influence, and thus also its legacy in the Hellenistic period. When we encounter comparable institutional and legal phenomena in numerous Hellenistic communities across different regions, it's worth considering these alternative forms of dissemination rather than taking for granted a hub and spoke model with a classical Athens as the original hub. There are indeed several reasons to question the extent of lasting Athenian influence in the Hellenistic period, specifically in relation to this aspect of law enforcement and of the Athenian part played in any Hellenistic process of legal and institutional convergence. When viewed from an Athenian perspective, Athenian hegemonic influence in the Aegean may appear as a constant, albeit with fluctuations in the levels of Athenian control in particular regions, and that applies especially in Asia Minor in the 4th century, where really we are talking about wild fluctuations. When viewed from a non-Athenian perspective, many communities very likely experienced Athenian power as intermittent, and Athens itself as just one player among several, including neighboring communities vying for regional dominance. Even where Athens sought to impose a constitutional setup or to introduce modification of existing institutions and procedures to suit its own interests, its influence may often have been but shallow. The difficulties in assessing the extent of Athenian legal and institutional legacy arise even in relation to those communities in which Athenian influence had been both deep and of long duration in the 5th and 4th centuries. As suggested by John Marr, part of the Athenian legacy may in fact take the form of deliberate and perhaps even demonstrative rejection of Athenian institutions and procedures. And this, of course, was a point that was just made by Andrei as well. And here my example is in fact from 3rd century Delos. The law on wood, ID 509, instructs the board of Agora Normoi to carry out praxis of judgment debts within 10 days without being subject to oath denial. This immunity from complaints arising from their conduct in connection with the process of praxis is amply attested for other Greek communities in the Hellenistic period, but I haven't been able to find a single example from classical Athens. If anyone knows of one, please let me know. Another striking detail in the 3rd century Delian epigraphical record is the use of the hemiolion, i.e. the 150% surcharge, as a penalty for debtors missing their deadlines. The hemiolion is widely attested across the Hellenistic world, except for Athens. I've managed to find only 2 Athenian attestations earlier than the 2nd century AD. One is found in a speech by Socrates in the context of a dispute between a young Bosporan trader and the Bank of Hesione to be settled by the Bosporan king Satyros. The other attestation occurs in a Deme decree with provisions for local procedures of accountability. The appearance of the hemiolion in Delian administrative procedures may be just a trivial detail, but bearing in mind the acrimonious relations between Athens and Delos in relation to the administration of the sanctuary, which have been discussed in depth by Veronique Jankowski, it would not be at all surprising if independent Delos chose consciously to reject procedures associated with Athenian dominance. Even Imbros, a community for which the use of Athenian demotics is attested for the 3rd century, displays some very interesting deviations from attested Athenian procedures and practices in the classical period. IG 12851 contains the final parts on your handout of an enactment with instructions to a board of practorers to ensure that its stipulations are put into effect. If they fail to comply, each member of the board will incur a fine of 100 drachmae. So far, so familiar. But strikingly, our reckoning for the recalcitrant board is not its oathinae. Quite the contrary. The members are not permitted to undergo that process until they've paid their fine. Whatever the explanation for this back-to-front process of accountability, is a reminder that even apparently familiar procedural terminology may denote substantially different procedural realities. When considering the bulk of Hellenistic evidence for the involvement of officials in the process of praxis, it should be noted that a number of recurrent features are not attested in the surviving Athenian evidence. And again, I hedge my bets here because you never know when the next inscription is going to completely overthrow your argument from science. As far as it goes, the lack of Athenian, the phenomena that where we have a lack of Athenian attestations are actually anything but trivial. Among the most important is the one that I already mentioned, the granting of immunities from prosecution to officials who are in the process of carrying out praxis. In addition to 3rd century Delos, it's attested for communities as far afield as Amutson in Caria, Tomoe on the Black Sea, Delphi, Gortyn, and Heraclea in South Italy. Another important feature that I hadn't yet found parallel in the material from classical Athens is the attempt to compel officials through the threat of sanctions actively to recover judgment and contract debts. Attestations of this feature too is remarkably widespread in the Hellenistic world, including Argacine in the Aegean, Beroea, Sassos in the north, Kyme and Pergamon in Asia Minor, Libena in Crete, and Delphi. So what are the alternatives to Athens? I'm not saying that these are exclusive alternatives, but they are alternatives that we really need to consider as possible contributing factors to the kind of similarities that we can observe across the Eastern Mediterranean. The substantial variations on the fundamental themes of penalty enforcement, the active involvement by officials in the process, and principles of accountability and transparency suggest, as mentioned earlier, that we should consider these additional factors that may have contributed to the dissemination of legal procedures and principles, and in particular in relation to the execution of penal decisions. It can't be taken for granted that Hellenistic communities would have looked to classical Athens as a model, even if they were keen to label themselves as democratiae. One of the examples mentioned by Davide, of course, the proposed Eunikis of Tears and Libidos, has Kos as the model that the communities claim to have chosen as an interim measure. A 4th century example, early 4th century Sifnos, chooses chaos as a model. And the speaker refers to the laws of chaos as the laws that are prevailing in Sifnos, from which he himself is currently a refugee. Among the types of horizontal engagement that may have contributed substantially to a process of convergence are those of highly skilled professionals who moved between communities and who engaged in contractual relationship with cities, with sanctuaries, and with civic subdivisions. Penalty clauses and stipulations prescribing their enforcement are recurrent features of the contracts that have survived in our epigraphical record. Although the contracts usually give the impression of having been drawn up on terms decided by the community that commissioned the work, the extent to which these may have been influenced by formal or informal negotiation involving the contractors should not be underestimated. Contracts pertaining to sanctuaries and festivals in specific regional contexts, such as the regulation concerning technitai from 3rd century Euboea, are likely to have been particularly important as parts of such a process, especially at a regional level. A further contributing factor to be considered is that of penalty enforcement clauses in treaty arrangements. The format of Greek interstate treaties frequently bear a close resemblance to other types of contract, and the epigraphical attestations display a remarkable degree of continuity from the archaic period onwards, including in the framing of penalty clauses and clauses relating to praxis. And finally, the part played by the Pan-Hellenic sanctuaries in the process of dissemination of administrative and legal procedures and principles should be seriously considered. It's interesting to note that some of the procedural features that appear to have deviated from those of classical Athens are tested for classical and Hellenistic Delphi and for Olympia. The potential importance both of horizontal and even bottom-up engagement rather than a top-down model makes it considerably harder to identify institutions and procedures as a clear and unambiguous part of an Athenian legacy. Moreover, in the specific area of penalty enforcement, a number of key features that are shared between several Hellenistic communities are attested already in the archaic and early classical period, while significant local and regional differences continue to exist throughout the Hellenistic period. This strongly suggests that the process of convergence may significantly predate the Hellenistic period, and there are also important questions to be asked in regard to its possible acceleration in the 3rd and 2nd centuries. But I'll leave that for later. Thank you.
Thank you, Lene.